Talk shoes. Recorded live.
Hello, ladies and gentlemen. I had one of our listeners call me before I took off and went and seen our son. But before I left, he told me to get into Title 49, Code of Federal Regulations, 523.3. And I got into this, and it's what we've been looking for, because what it says, Title 49 CFR 523.3, automobile. Automobile. An automobile is any four-wheel vehicle that is propelled by fuel or by alternate fuel, manufactured primarily for the use on public streets, roads, highways, and weighs less than 10,000 pounds gross vehicle weight, except a vehicle operated on a rail line. A vehicle manufacturer is different stages by two or more manufacturers. If no intermediate or final stage, manufacturer of the vehicle manufactured more than 10,000 pound stage vehicle per year or work truck. The following vehicle rated at more than 6,000 pounds but less than 10,000 pounds gross weight vehicle weights are determined to be automobiles. Now remember what you and I sit down and I have pointed out to you is that commercial motor vehicles sit down and they have the gross weight starting at 10,001 pound. 10,001 pound. And it goes up to 26,001 pound and higher. Ladies and gentlemen, this is what we've been looking for. It is also in Title 49 of the United States Code, Subtitle 6, wait a minute, let me pull it up here. Yeah, Subtitle 6, Part A, Chapter 305. 49 U.S.C. Chapter 305, National Motor Vehicle Title Information System. Title 49 U.S.C. Code 30501 Definition. In this chapter, automobile has the same meaning given that term in Section 32901A of this title. Certificate of title means a document issued by a state showing ownership of an automobile. Let me go down to Title 49, U.S.C. 32901 definition. Except as provided in Section 32908 of this title, automobile means a four-wheel vehicle that is propelled by fuel or by alternate fuel, manufactured primarily for the use of public streets or on highways, and weighs less than 10,000 pounds gross weight. Gross vehicle weight, except a vehicle operated only on a rail line. Work truck. Automobile manufactured by a manufacturer includes any automobile manufactured by a person that controls is controlled by or is under common control with the manufacturer, but does not include an automobile manufactured by the person that is exported not later than 30 days at the end of the month. Well, wait a minute. Commercial, medium, and heavy-duty trucks on highway means on a highway vehicles with a gross weight rating at 10,000 or more. Ladies and gentlemen, work truck means that has a rating between 8,500 and 10,000 pounds. Not 10,001, between 8,500 and 10. It is considered an automobile. I have yet, underneath these definitions, and looking at what we have been dealing with driver's licenses, and all these issues with driver's licenses, under Title 49 CFR Part 392, driving a commercial motor vehicle. It goes through and it lists everything that a commercial motor vehicle is except for an automobile or a light truck. Under Title 18, USD Code, Section 31, definitions. I've been calling it chapter, and I apologize. It's Section 31. Title 18, Section 31, definition. Motor vehicle. The term motor vehicle means any description of a carriage or other propelled or drawn by mechanical power and used for commercial purposes on the highway and the transporting of passengers and property or cargo. So, ladies and gentlemen, they're classifying what we're driving as motor vehicles in order to pull us in on the commerce side, not automobiles. On the non-commerce side. But we have addressed these issues before and got into what it means. But up until time, we haven't been able to find the word automobile, and we have found it. And it shows that automobiles are not in commerce and therefore does not require a driver's license or a registration to be in commerce, as they are allowing us to believe. These are significant finds for what we have discovered here. Also under Title 49, I want you to read what we also found under Title 49, the United States Code 40102 definition. Citizen of the United States means an individual who is a citizen of the United States. A partnership, each of whose party is an individual who is a citizen of the United States, or a corporation or association organized under the laws of the United States, or a state, a District of Columbia, or a territory or a possession of the United States, of which the President and at least 2/3 of the Board of Directors and other management officers are citizens of the United States, which is under the actual control of the citizens of the United States, and in which at least 75% of the voting interest is owned or controlled by persons that are citizens of the United States. Let me go back and read that again, because, ladies and gentlemen, what they're saying here is that you and I are in control under Title 49, Subchapter 7, Part A, Subpart I, Chapter 401, Section 40102, Definitions. Let me go back and read this again to you. Citizen of the United States means an individual who is a citizen of the United States. A partnership, each of whose partners is an individual who is a citizen of the United States, or a corporation or an association organized under the laws of the United States, or a state, the District of Columbia, or a territory or possession of the United States, of which the President and at least 2/3 of the Board of Directors and other managing officers or citizens of the states which is under the control of citizens of the United States, and which at least 75% of the voting interest is owned or controlled by persons that are citizens of the United States. Here they are coming back in and classifying the president and board directors, not Congress, board directors. They're actually addressing them as a corporation. It's under Title 49, Subtitle 7, Part A, Subpart I, Chapter 401, Section 40102. Now, let me read something else to you. Because it has the definition of the word person in here. As I find it, I will read it to you. I will give you the section of what we're dealing with. Got one of these documents. Okay. Title 49 CFR 31.2 definition. Title 49 CFR 31.2 definition. If you go down and read, it says, individual means a natural person. That's the definition of an individual. It means a natural person. Under 49 CFR 31.2 definitions. But I want to point out some other things to you as well, because, ladies and gentlemen, they want to come back in, they want to play the word game, and we could come back in and we can address the issue here, because under Title 49, United States Code, Subtitle 6, Motor Vehicle and Driver Program, which brings us up to Title 49, U.S.C. Code, Chapter 311, Commercial Motor Vehicle Safety. Title 49, United States Code, Section 31132, definition. Commercial motor vehicle means a self-propelled or towed vehicle used on the highway in interstate commerce to transport passengers or property. If the vehicle has a gross weight rating of gross vehicle weight of at least 10,001 pounds, whichever is greater. Employee means an operator of a commercial motor vehicle, including an independent contractor when operating a commercial motor vehicle. That means it's of 10,001 pound or greater. That's classified as a commercial motor vehicle, not an automobile, but a commercial motor vehicle. Remember what we are getting into, what we're using words here? State means a state of the United States, the District of Columbia. And in sections 31136 and 31140 through 31142 of this title, a political subdivision of a state. Commercial driver's license, Title 49, Subtitle 6, Part B, Chapter 313, Section 31301, 49 U.S.C., Section 31301, definition. Commercial driver's license means license issued by a state to an individual authorized the individual to operate a class of commercial motor vehicle. Commercial motor vehicle means a motor vehicle used in commerce to transport passengers or property that has a gross weight rating of gross vehicle weight of at least 26,001 pounds, whichever is greater, or lesser gross vehicle weight of a gross vehicle weight by the Secretary of Transportation prescribed by regulations, but not less than a gross vehicle weight of 10,001 pound. That is commercial. That is commerce. Remember what I read to you about automobile? It has a weight of 10,000 or less. Ladies and gentlemen, this is where we're getting into the definitional side of this thing. Let me go back and read to you. 49 CFR 523.3, automobile. An automobile is any four-wheel vehicle. Now you notice it didn't say motor vehicle. It just used the word vehicle. An automobile is any four-wheel vehicle that is propelled by fuel or by alternate fuel, manufactured primarily for use on public streets, roads, and highways. You notice it's not saying interstate. That deals with interstate commerce. It has rates at less than 10,000 pound gross vehicle weight. A work truck. The following vehicle rated at more than 6,000 pounds and less than 10,000 pound gross weight are determined to be automobiles. Vehicles which satisfy the criteria of 523.5 relating to light trucks, but for their gross vehicle weight and rating has a basic vehicle frontal area of 45 square feet or less, has a curb weight of 6,000 pounds or less, has a gross vehicle rating of 8,500 pounds or less. Ladies and gentlemen, the caller that got a hold of me and gave me this information, we're now putting it out to you. Again, let me go back and read. Commercial driver's license means a license issued by the state to an individual authorized the individual to operate a class of commercial motor vehicle. Has a gross vehicle weight rating or gross vehicle weight at least 26,001 pound, whichever is greater, or a lesser gross vehicle weight rating at a gross vehicle weight the Secretary of Transportation prescribed by regulating, but not less than a gross weight rating at 10,001 pound. Commercial motor vehicle means a motor vehicle used in commerce to transport passengers or property. Motor vehicle. This is under Title 49, Section 31301. Go on to Section 12. Motor vehicle means a vehicle, machine, tractor, trailer, or semi-trailer propelled or drawn by mechanical power and used on public streets, roads, and highway, but does not include a vehicle, machine, tractor, trailer, or semi-trailer operate only on a rail system or custom harvest by farm machinery. You notice they did not use the word automobile or light truck. Again, state means a state of the United States and the District of Columbia. The United States means the states of the United States and the District of Columbia. State grants. Title 49, Subtitle 6, Part B, Chapter 311, Subchapter I. 49, United States, Section 31101, Definition. Commercial motor vehicle means a self-propelled or towed vehicle used on the highway in commerce, specifically for transporting passengers or cargoes, if the vehicle has a gross weight of at least 10,001 pounds, whichever is greater. An employee means a driver of a commercial motor vehicle. Ladies and gentlemen, stop and think about what's being said here on why you have to have a driver's license. The state has you in commerce and you are not being paid. You're not collecting your wages on this. I want to bring something else up to you. Of all the different things that we've come across, we have we are addressing the difference between an automobile and a light truck. That of a commercial motor vehicle, which is defined for carrying produce, cargo, and people. It is for hire. You're in commerce. Ladies and gentlemen, this is giving you education and knowledge of what we're dealing with the words and how they are misusing them in these courtrooms and how we need to start addressing them. I want to thank the listener for bringing that information on automobile under Title 49 CFR to me, which led me over to all these other things. Now, I want to bring you up on something else. Judicial Review of Standards. Title 49, Subtitle 6, Part A, Chapter 301, Subchapter 4, Section 30161. That's Title 49, Subtitle 6, Part A, Chapter 301, Subchapter 4, Section 30161. Judicial Review of Standard. Filing and venue. A person adversely affected by an order prescribing a motor vehicle safety standard under this chapter may apply for review of the order by filing a petition for review in the Court of Appeals of the United States for the circuit in which the person resides or has a principal place of business. The petition must be filed not later than 59 days after the order is issued. Notification. The clerk of the courts shall send immediately a copy of the petition to the Secretary of Transportation. The Secretary shall file with the court a record of the proceedings in which the order was prescribed. Additional proceedings. On request of petitioner, the court may order the Secretary to release additional evidence and evidence in rebuttal if the court is satisfied that the additional evidence is material and there was reasonable grounds for not presenting the evidence in the proceedings before the Secretary. The Secretary may modify findings of facts or make new findings because of the additional evidence present. The Secretary shall find a model or new findings on recommendation to modify or set aside the order and the additional evidence with the court. Now, ladies and gentlemen, you have not heard me say under this Judicial Review of Standards under Title 49, Subtitle 6, Part A, Chapter 301, Subchapter 4, Section 30161. The only court that you heard me was the Court of Appeals of the United States. The Secretary of Transportation has to make all determinations on traffic issues. Not your local yokels, not your local courts. Petition by interest party for standards and enforcement. Title 49, United States Code 30162. Action of the Secretary. The Secretary shall grant or deny a petition not later than 120 days after the petition is filed. If a petition is granted, the Secretary shall bring the proceedings promptly. If a petition is denied, the Secretary shall publish the reason for the denial in the Federal Registry. Ladies and gentlemen, do you think we're going into the wrong court? Do you think we're not being properly served and noticed into the proper system? Ladies and gentlemen, this is in Title 49, United States Code, Judicial Review of Standards. That Secretary of Transportation has to hear the case, not the local judge. Not your local police officers dragging you in. Not the local state highway patrol. Not the local sheriff. Not into the local courts. This is a federal issue. It's their books. This is why I'm very carefully and slowly telling you the section, so you could go look it up for yourself. Ignorance is no excuse on our side of the fence. It's what they keep selling us. You got no excuse for being ignorant. But yet you and I are not giving updates, and you and I are not being told about these laws. When we bring them up, they want to sidestep them and call them legal errors because they don't want to face and deal with the issue because they got caught with their hands in a cookie jar. I want to read something else to you. That I have found. But I want to sit down and, especially for you people in the District of Columbia, from what we just read here, just a few short verses, the District of Columbia, under the Highway Safety Act, under Title 49, is considered a state, just like any other state. That means you get the same rights as the rest of us. You're just being buffaloed and lied to. You're being buffaloed and you're being lied to. But I'm glad the gentleman that sent me this information on automobiles found it. Yes, it makes a distinct difference between automobiles and motor vehicles. Makes a big difference whether you're in commerce or whether you're private. Now, it's how you put it together and how you word it and how you go back and do your research on how you want to deal with this. Like we said, I can't guarantee that a judge is going to be honorable and honest. But like we also sat back and said, there's no such thing as a legal error committed by a judge or a lawyer. They get updates on the laws on a regular basis. They get updates on Supreme Court decisions on a regular basis. You and I do not get them. So if ignorance on our side is absolutely no excuse, then there's no excuse when they are being given the laws and the updates for them not to know it and not for them not to adhere by it. And when you bring it up, for them to suppress it. Ladies and gentlemen, your knowledge and your understanding of this is the issue. All this stuff is written in their books. This is why I took the time and I precisely told you exactly where this stuff was at. It's not my comment. It's their books. It's their black ink. It's their white paper. They wrote it. They wrote this stuff down, not you and I. But this is just some more information that we have been looking for that we got a hold of for definitions of automobiles, light trucks, even motorcycles fall underneath this. And if they're going to have you and I listed as commercial drivers with a commercial driver's license for the state, then you and I are entitled to pay. You and I are entitled to wages. Because if our vehicles are registered to the state as state-owned property, because what it does say about the automobile, you have to have a title, which is understandable if you stop and think. This way it's titled to you for ownership. It doesn't say that you have to register, but it does under commerce says you have to register with a plate under commerce. But all it says under automobiles is that you are to have it titled and have a certificate of title, which shows that you own it, which is understandable and acceptable at this point. There has to be a little give and take here on what we're doing. But that give and take has to go on the other side. But we're bringing in their own words, their own definitions, ladies and gentlemen. They're the ones that wrote this stuff. They're the ones who defined this. This is congressional definitions of what words mean and how they are specifically used. It's up to us to come back in and express it. It's up to us to come back in and address it and point it out. And if we do not sit here and address it and point it out and stand our ground on this, how do you ever figure to get ahead and move on? And they're going to try to suppress the evidence, but this is where you object. They're going to sit back and say, well, we will address this later, and they never do, and you object. Because these judges know what evidence not to allow to be put into the record for errors on their side. They're trained well to prevent you from doing this. And ladies and gentlemen, this is something that you have to turn around and be able to push and address. And if you don't, then you lose. All right, under Title 49, Subtitle 6, Part C, Chapter 329, Section 329.01, Definition. Except as provided in Section 32908 of this title, automobile means a four-wheel vehicle that is propelled by fuel or by alternate manufacturer primarily for use on public streets, roads, and highways, and weighs less than 10,000 pounds. Okay? Again, we're getting into commercial, medium, and heavy-duty trucks on highways. Means on a highway vehicle that has a gross weight of less than 10,000 pounds, has a rating of 10,000 pounds or more. Work truck, between 8,500 and 10,000. There is a section, I need to find it here, that dealt with employees. And ladies and gentlemen, what was listed in here as employees, you and I were not part. All right, under Title 49, USC Code, Section 31105, 49 USC 31105. Employees Protection. Wasn't that nice? A person may not discharge an employee or discipline or discriminate against an employee regarding pay, term, or privileges of unemployment because A, the employee or another person at the employee's request has filed a complaint or began a proceeding relating to the violation of commercial motor vehicle safety or security regulation standard or order, or has testified or will testify in the proceedings, or if the person prescribes that the employee has filed or is about to file a complaint or has begun or is about to begin a proceeding relating to a violation of commercial motor vehicle safety or security regulation standard, or an employee refused to operate a vehicle because the operation violates a regulation standard. Ladies and gentlemen, you can go all the way down through here. All the way down through here. It says judicial review and venue. A person adversely affected by an order issued after a hearing under Section B of this section may file a petition for review not later than 60 days after the order is issued in the Court of Appeals of the United States for the circuit in which the violation occurred or the person resides on the date of the violation. Review shall conform to Chapter 7 of Title 5. The review of Title 5. Well, Title 5 is administration. Review shall be heard and decided expeditiously in order of the Secretary of Labor, subject to review. Ladies and gentlemen, I'm telling you, when they go down through here, you and I do not meet the qualification definition in this section. This is where, down here, J, definition. In this section, employee means a driver of a commercial motor vehicle, including an independent contractor, when personally operating a commercial motor vehicle, a mechanic, a freight handler, or an individual, not an employer, who directly affects the commercial motor vehicle safety or security, of course, okay? Ladies and gentlemen, they have you and I down as employees because we are driving commercial motor vehicles under this section of Title 49, Section 31105, Employees Protection. Now, if you and I are not employees, and you and I should not be having a commercial motor driver's license, and our vehicles should not be registered to the state, they should be listed as automobiles on the private side. Otherwise, you and I are listed as employees, and this now comes into a labor management dispute. You and I have not been paid. They have not maintained their cars. They have not paid the insurance. They have not made one single car payment on it. They haven't paid the taxes on it. This is under Title 49, United States Code 31105, Employee Protection. We're giving you a lot of information tonight for you to sit back, do your own research, go back and get your own understanding on this. This is part of what I've been doing, among other things, for what my own personal cases are involved. And because of this new information, we're opening up another new case here in North Carolina on this very issue, as I have been fighting them on this very topic, and as nobody is listed as employees of the state. They're listed as private contractors or private entities. They still have to come in compliance with these federal regulations, because that's what the governor agreed to. But ladies and gentlemen, take the time, go back and read and understand. Because there is a definition for automobile compared to that of a motor vehicle in commerce. Congress made the distinction in the law. The court system and the lawyers are not abiding by it because there's money to be made by not making the proper arguments. Your education and your knowledge is up to you to maintain. You can't walk into the court on someone else's knowledge and someone else's paperwork and you don't know the first thing about it. You have to take the time to train yourself and educate yourself. So when you walk into that courtroom, you have the knowledge and understanding of all this stuff. It's your obligation. It's not up to me for me to sit down and create the paperwork for you to walk in here and you don't know the first thing about it. This is what's hurting so many people out here, is you're taking someone else's paperwork and you're putting it in as if it's your own and you don't know the first thing about it and you wonder why you're getting your butt handed to you. It's hard enough to fight these people whenever you know your own paperwork. But it's even harder to fight them whenever you're using someone else's and you cannot explain it. I gave you some information here tonight. Go do the research. Go look it up. Go understand it and go use it. But what we're trying to separate ourselves, because after all, they created the separation because they created the different titles and defined the vehicles. They just had everything hid, to which we have now found. So take this information, take it for what it's worth, go do your own research, and go put it together on your own traffic issues. But ladies and gentlemen, this is what this show is all about. Going back in and researching their laws and their congressional statutes and their definitions of their words of how they're taking them out of context, and go back and shove their own words before them on how they misled it and misconstrued it and intentionally committed fraud and false documentation before the court. And the judge has allowed it. So take the time, do your research, do your due diligence. You only have one shot. And that one time in court may make the difference whether you walk out of there or whether you stay in a gray bar motel because you didn't do your job right, because it was more important to use someone else's paperwork and not understand it. This is why I tell you, whenever you go to use somebody else's paperwork, get all the information. That's why when I give you my paperwork, I give you all my information. That's what these shows are for, is telling you where this information is at, so you can go back in and put it together yourself with full knowledge that you are going to be able to defend it. Thank you, and we'll talk to you later.